Hey guys, Paul Rabelais, estate attorney here. Wanted to go over with you what kinds of things what kinds of information should families gather and collect and bring in to the probate lawyer when they meet with that probate lawyer for the first time after a loved one passes away. So I've been involved in hundreds or thousands of these meetings, and really the more efficient we can make it, the quicker things can go. It's a stressful time. Families having to deal with so much stuff, and it really can get difficult if things don't stay organized. So let me give an example, and then I'll go through the four things that I think are really important to get together and present to the lawyer who's going to be helping settle the estate. So let's just say, mom passed away, maybe dad died years ago, and mom had 3 kids. Maybe she had a will, maybe she didn't. But it's been a couple of weeks since mom died, and now the one or more of the kids is saying, you know what, I discovered that mom's accounts are frozen. We can't sell our house, we can't sell our car. We need to get with a lawyer and start, the process rolling for getting her estate settled. So call the lawyer, schedule an appointment, go in. What should you bring? Well, I really nailed it down to 4 different things. The first thing, it seems kind of obvious, but it's not, is make sure you bring the will, the last will and testament, to that attorney, because many of the steps that the family and the lawyers have to take are based in large part on the exact provisions of the will. So, I've had people come in and they'll say, my dad died, we need to, get his estate settled. Did you bring the will? No, I didn't bring the will. I just figured that would come later. So, but really the will needs, first, it's the first thing that we look at. Some people mistakenly believe that there's going to be some formal reading of the will. You see it on TV, you see it in the movies. Lawyer sits at the end of the table, family around the conference room table, lawyer pulls out the will and starts reading it. Doesn't happen that way, mainly because there's so much stuff in wills that's irrelevant, and people would fall asleep probably if you started reading what could be a 15-page will when you're really just trying to figure out who they left stuff to and who's in charge. So there is typically no formal reading of the will. Sure, copies get made and distributed just to show what was done. But the will does control the process, and when people don't bring the will, I ask them, what did the will say? And I've been doing this enough to know that I can't rely on what they tell me they think the will says, because when I get the will, most of the time it doesn't say what they thought it said, because there's so many little nuances there. So we want to make sure you bring in the original, actually. Maybe it was signed in blue ink. You can tell it's the original. Maybe it has the raised notary seal, because it's that original that must be filed at the courthouse. If you don't bring in the original, at least bring in a copy so everyone will know the terms of it. But bring in that original, because at least in our office, and this is all that we do, we can get the initial set of pleadings, get the initial set of pleadings prepared, get that hustled over to the courthouse to get things started. Can't do that without the original will. So bring the will. Number 2, bring any other relevant estate documents. Some people have trusts. Some people have marriage contracts. Some people need to bring in prior probate documents. When mom died, oftentimes we need to see dad's succession or probate documents, because that indicates how he may have left things to mom. Maybe mom inherited some property from her parents, and so we need to see her parents' probate records or judgments to accurately reflect what mom owned. So bottom line on the other relevant estate legal documents is, if it looks important, bring it, and then we can always, by process of elimination, say we need this, we don't need this, but great that you brought it in, but we don't need this and we need this. So number 2, bring in all the other relevant estate documents. Number 3, bring in a list of the assets and debts that the person had, when they died. Most people, when they pass away, many of them own a home or other real estate. Some own bank accounts, credit union accounts, others own brokerage accounts. Many own vehicles, and so the detailed information all has to be laid out in the court documents. And so bring all that in so we'll know what we're working with, even if you're not sure if it's relevant. For example, sometimes maybe a married couple, dad died, mom doesn't bring any of the account information on things that are in her name, even though it's community property with her husband. We need to know about that so we can, accurately list the assets and debts on the necessary court pleadings. And then finally, it's real important, often it delays things when this isn't done right, is you want to make sure all of the, I call them decision makers, come into that first visit with the attorney. Go back to our example. Mom had 3 children. One child comes into the office, perhaps with the will, with the list of assets. We talk through all of the steps that are necessary to complete mom's estate settlement from start to finish. You're ready to get started. No, I need to go back to my 2 siblings because I can't do anything without talking to them first. So if they had either been present in that discussion or if even they would have been on a conference call, things would have been much more efficient. What happens is that one child who was present goes home, tries to talk to the other 2 about the procedural steps. Those 2 start asking questions that the one who was present can't answer. Delay, got to start all over again, frustration. And so really important that those participants all participate in the first meeting, either physically or via conference call. And there's so many different ways with technology now to get people to participate even though they're not right there. So really important that all of those kind of decision makers get to hear it from the horse's mouth rather than secondhand, third-hand knowledge. A lot of procedural steps. Gets really complicated if you're not, familiar with all the concepts, all the terms, all the moving parts. So there you have it, the 4 things to get together and make sure that you have organized when you meet with the estate attorney for the first time to get an estate settled. Bring the will, bring the other relevant estate documents, bring a list of assets and debts, and bring all the participants that are involved. Boy, you'll be really ahead of the game on getting things done and keeping people in the right frame of mind so they don't get frustrated, mad, and turns into a far less than pleasant atmosphere in a difficult environment to begin with. So that's there you have it. Hope all that helps. Feel free to comment. Your experiences can help others. If you thought the video provided some value, hit the like button, subscribe. You'll give you a lot more. Have a great day.